If you're watching this video, then you're probably ready to close a probate estate in the state of Missouri. And I know at this point you are probably ready to be done. So today what we're doing is I'm going to walk you through exactly when and how to close a probate estate in the state of Missouri, whether you're handling this independently or under a supervised administration. Hi guys, my name is Dan Schnurbush. I'm an estate and probate attorney out of St. Charles, Missouri. We represent clients in probate all across the state of Missouri. Now, the first thing to know is when can you actually close a decedent's probate estate? And in general, when you can close is at the end of what's called the non-claim period, or the period that creditors are allowed to file claims against the estate. That's the earliest point at which you can close. And in the state of Missouri, generally that's about 6 months and 10 days from the date of first publication of notice of letters granted. So at the beginning of the case, you'll remember you may have got your letters of administration or letters testamentary if there was a will, and your attorney should have published in the newspaper, should have published the notification of your appointment in the newspaper. And that starts the 6-month and 10-day clock. So that's usually the earliest point that you could legally file to close. But secondarily, you're going to need to make sure the estate is in condition to be closed. So that's where we get into the next step of what needs to be done in order to practically close the estate. So the earliest legal time you can do it is by 6 months. So we try to handle all of the following tasks before that 6 months is up so that we can file for closing as soon as reasonably possible. So here are some of the things you need to do. Number one is you need to make sure that all creditor claims have been dealt with. Either they need to be paid if they are valid and enforceable. They need to have been noticed for hearing and brought on for hearing in most cases. And the judge will need to have either entered an order declaring them as valid and need to be paid, or dismissing them from the case. Okay. So we need to have creditor claims that have been filed in probate dealt with. Okay. You don't have to worry about anything that was never filed. You'll get calls, you'll get letters from like credit card companies and healthcare companies saying, oh, you owe us money. But unless they file a creditor claim in probate, generally speaking, they're not entitled to be paid. There are exceptions for creditors who are lien holders, like mortgage companies. They've got a lien on a car, for example. They don't necessarily have to follow the same procedures. So any claim that's been filed in probate needs to be dealt with before you can close. Number two is making sure that, and this is kind of related to number one, but number two is making sure that you've dealt with taxes, okay? So when you're dealing with a full probate administration, you want to make sure to pay the final personal income taxes for the deceased person. You'll want to file a personal income tax return, their final tax return, for them as an individual person. Now, the estate itself is a separate taxable entity. So if the estate itself after death generated income exceeding a very low threshold, I think it's like $600 a year or something like that, then the estate itself might need to file an income tax return as well. This is something you should do with an accountant or CPA, okay? Generally, we don't see this very often unless the estate had like an ongoing business or had a lot of taxable brokerage assets, for example, or if there was just a long period of time between the time that the estate was opened and closed, if property was sold during administration. Because it can be the case that, for example, you have a piece of real estate that appreciates in value during probate and you sell it later down the line. That could potentially generate some taxable income. Or if you sell other like stocks and bonds that appreciate during probate, if the estate is left open for a while for whatever reason, that can generate income. Or if there's a really large taxable investment account, for example, that generates interest or dividends or something exceeding $600 a year, that could potentially happen. But the vast majority of probate cases that we see generally have things like a family home in it, cars, typically modest bank accounts. Most of the time, people are pretty good about setting beneficiaries on their brokerage accounts, life insurance, things like that. Life insurance doesn't generate taxable income. So it's actually not that common for an estate to have an income tax return because estates generally don't have that much in income. Some do, and your situation may need to be looked at independently, but many do not. So the main thing is making sure that the deceased person's tax obligations have been dealt with. So, making sure that their final tax return has been paid, making sure to file what's called an IRS form 4810, which is it's called a request for prompt assessment. And what that form does is it says, hey, IRS, this person is deceased. I want you, for the past 5 years, whatever, I want you to tell me now whether you believe that they owe any income taxes or if they had a deficiency in a prior year or something like that. I want you, IRS, to tell me now because we're doing probate now and I want to wrap all this up, please. So that's what that form says. We're doing it now. Here's the forms that I want you to make sure that we're assessed on. And that gives the IRS a certain period of time, a shortened period of time to respond if they think that they have a valid basis for asserting tax liability against the deceased person. This is one way of preventing those like rogue claims from the IRS where we're getting ready to file for closing and then all of a sudden we get a random claim from the IRS. This is designed to help cut that off. From the beginning, we file this and we say, hey, IRS, tell us what you think we owe, and we'll deal with it at that time. All right. So that's a form we want to see get filed early on. In larger estates where there is a likelihood of a tax exposure, we want to get you in touch with a CPA and file that final tax return along with that 4810 form right away. The other tax form that is really helpful to file is a form 5495. This is a request for discharge from fiduciary liability. So what that means is we're filing a form at the end of probate that says, we've sent in this request for prompt assessment. We've filed these various tax returns. Dear IRS, I'm a representative of an estate. Please discharge me from any personal liability on these taxes. And the reason for that is in Missouri, if you open a probate estate, a full probate administration, the government is not bound by the creditor filing deadlines. They can file at any time after the estate has been opened. Okay, so we don't want that to happen. And the other thing is, in Missouri, if you distribute property and there is a valid and unpaid creditor out there, including the government, you can be personally responsible for not paying that creditor. Okay, so we want to make sure to cut off that liability so that they can't come after you personally as a representative and say, hey, we were a tax bill that you should have paid on grandma's behalf and you didn't. So that's what that form is about. It's telling the IRS, hey, we've done our best, please discharge me. And they get a certain amount of time to respond. But if they don't, generally there will be a automatic discharge of liability where they can't come back after you at any point later down the line. Okay, a couple of big important things. So dealing with settling creditor claims, dealing with the taxes, talk to a CPA, get those forms filed. If your CPA doesn't know to file those forms, make sure that they are told about that. A lot of CPAs are not super familiar dealing with estates and fiduciaries, so making sure that those forms are filed. The other major thing we're going to need to do before closing is prepare a final accounting in a supervised estate. So what that is a line by line. Here's what came into the estate. Here's what went out of the estate. This is most common when the estate needs to make a lot of transactions, like hiring, a clean out company for a house or things like that. We need to have line by line. Here's what we paid. Here's what came in. Here's a distribution we made. So we need to track all that in an accounting. In a supervised estate, you're also going to need to get canceled checks for every distribution or receipts. You're going to need to get receipts for every expense that you've incurred. So you need to keep track of all that, very, very careful track of all that in a supervised estate. All right. So once we have that accounting prepared, we're going to give that to the court and we're going to say, in an independent administration, we're going to prepare that accounting and some closing paperwork. We're going to send some waiver documents to all the heirs that say, hey, I'm going to waive the formalities. Generally, this is not a big deal in independent estates. If people were willing to sign to waive to allow you to serve independently, in many cases, they're also willing to sign to waive to allow you to close without the full formality of a supervised closing. So in many cases, that can mean they waive the full formal accounting. They might waive a hearing. They might waive notice for anything that gets filed in court. It can dramatically simplify things. So in independent estates, we always try to send those waivers to get all of the heirs to consent to the distribution so that we can file it, get it split, and get it done. In a supervised estate, by contrast, we just got to file it. We got to file it. We got to notice it for hearing. We got to publish in the newspaper again. We got to notify everybody that it's time to close. You got to speak now or forever hold your peace. We have to have a hearing. We get approval of the final settlement, which is the income and expense statement. We get approval of the assets. and we get approval of the final proposed distribution. So it might say, hey, we've got 3 kids. Mom died. She had 3 kids. Here's the 3 kids. We propose splitting it 1/3, 1/3, 1/3. Sometimes you can get more creative if people come to an agreement or there's some kind of disagreement that needs to be resolved. A lot of that can be dealt with prior to closing. Okay. So that's kind of what you should expect in a independent versus supervised closing. Independent is generally much faster, much easier, because most of the time we'll be getting waivers from the heirs. Supervised, generally much longer, more laborious. They're going to be audited by the auditing department. The auditing department is going to cross-check everything you did and make sure it's exactly perfect. Even slight deviations in, line items on the accounting can lead to imbalances and slow things down. So it's very important, especially during a supervised estate, to make sure you're getting the documents to your attorney, making sure they have bank statements for every month that you had a bank statement, a bank open for the estate account, a bank account open, getting them canceled checks for every payment or distribution that you made out of the estate, getting receipts for any expenses that you paid on behalf of the estate. Things like that help to expedite and avoid any kind of pitfalls. So what are some common pitfalls where we see a lot of errors being made? We see people making goofs on the tax filing situation. Most of the time, these actually don't follow people very often. The IRS, oftentimes, they're understaffed. They don't have the resources to track a lot of these, but it's still a good idea to be safe rather than sorry. Get those IRS tax forms filed. A lot of times we see documentation errors, people losing receipts or expenses or documentation in support of that. So keeping track of that, keeping good records from the beginning is very helpful, especially in a supervised estate. Making sure that we wait long enough and to the point where we're allowed to close. And then the last thing is kind of making sure that we're leaving enough in reserves in the estate prior to making any distributions or payments in order to satisfy things like legal fees, like tax fees, like court costs, anything like that, making sure there's enough money left over to cover all those things before we do a final distribution. Now, in some states, you're allowed to do this on your own. In Missouri, you're not. You have to have an attorney throughout the entire probate process. So you're probably working with somebody at this point already. But generally, this is kind of the roadmap to what you should expect in closing out the estate. Other odds and ends. If there's real estate that needed to be sold, that needs to be taken care of. If there's a business that needed to be closed, that needs to be taken care of prior to closing. Filing all that stuff with the Secretary of State to make sure that they've been notified of the cessation of the business. So definitely check out some of our other videos if you want to learn more about the probate process. But this is a nutshell on what you need to know about closing in the state of Missouri. If you enjoyed this content, definitely subscribe, like and subscribe for the algorithm so that you and other people like you can find our videos. And if you have more questions, don't hesitate to reach out to our firm. We may be able to help you. Again, we help clients across the state of Missouri with probate and estate administration. All right, that's it for this time. Thanks, guys. Take care.